Hello friends, welcome to EPG Pathshala. I am Dr. Ananya Chakravarti from National Law University, Odisha. I will discuss the paper titled Social Legislations and Crime. The module name is The Prohibition of Employment as Manual Scavengers and Their Rehabilitation Act 2013. This discussion is related to the Prohibition of Employment as Manual Scavengers and Their Rehabilitation Act 2013. The objective is to make you aware of the salient features of the legislation while sensitizing about the great amount of humiliation that the manual scavengers go through, by which all the constitutional values are sacrificed. This discussion has a wide scope starting from social legislations, the practice of using manual scavengers, the magnitude of the problem faced by them, the constitutional guarantees, the legislations enacted by the government for putting an end to this practice, also international perspectives to the problem, as well as the salient features of the concerned legislation as well as the gaps therein. Unlike in the primitive societies, wherein customs had unquestioned compliance, laws in the modern days are largely made by state to regulate behavior of both individuals and institutions, so that order prevails in the society. The origin, concept and purpose of law have been understood differently by different schools of legal thought. Under the sociological definition of law, the view that broadly emerges is that law is a means of social control serving a social purpose, and state secures compliance by external coercion. Therefore, laws to come into existence require a society where the members agree upon certain values, and gradual observance by the member is the beginning of law. Social customs, traditions, religious prescription and legislations have controlled and directed individual action into desirable behavior. Author Ranjana Sehgal emphasizes that social legislations are such laws which are enacted with the special purposes of improving the socio-economic position of the specific groups such as women, children, elderly, scheduled castes, scheduled tribes, etc. The Prohibition of Employment as Manual Scavengers and Their Rehabilitation Act 2013 is an example of social legislation which addresses a social evil which has existed in India since the Puranic age, which further continued during Buddhist, Mauryan, Mughal and British periods. Manual scavenging is a caste-centered and heritable profession, and it is made worse with the belief that those born in the community are considered agents of pollution due to their background of social hierarchy centered on birth. The appalling hardship, humiliation and exploitation faced by them is unmatched in human history. Now, magnitude of the problem. Manual scavengers belonging to the most excluded and exploited communities among the Dalits. They suffer from different kind of health problems, including viral and bacterial infections, with deaths also being reported in some cases while doing the job. The socio-economic and caste census 2011 reveals that around 1,80,657 households are engaged in this degrading work for a livelihood, while 7,94,390 dry latrines where the human excreta is cleaned manually, of which 73% are in the rural area. As per Ministry of Social Justice and Empowerment survey of manual scavengers in statutory towns, there are presently 11,904 manual scavengers in statutory towns and rural areas. Now, speaking about the international perspective, the deplorable condition of manual scavengers has been discussed by the international forums, including the United Nations. In 2009, the Subcommission on the Promotion and Protection of Human Rights constituted the special rapporteurs to study the issue of discrimination based on work and descent at a global level. Their report comprises of draft principles and guidelines for the effective elimination of discrimination based on work and descent. It calls upon both national and local governments to ensure the complete eradication of manual scavenging and other unhygienic working conditions in harmony with international standards, and ask governments to enact and implement legislations guaranteeing decent work, a living wage and labour rights for the affected groups. The Committee on Economic, Social and Cultural Rights, the Committee on the Elimination of Racial Discrimination and the Committee on the Rights of Child all have called upon India to end manual scavenging by their concluding observations. International legal instruments like the Universal Declaration of Human Rights, also the Convention on Elimination of Racial Discrimination and the Convention for Elimination of all forms of discrimination against women have guaranteed mankind fundamental human rights to support the quest of ensuring that the manual scavengers have every right to live with dignity. The relevant provisions under these instruments entitle individuals to all rights and freedoms without any form of discrimination on any ground, right to fair and favourable compensation, so that he and his family may have an existence worthy of human dignity, which may be further supported by other instruments of social protection. For example, Articles 1, 2 and 23 of UDHR. Also under Article 2 of Convention on Elimination of Racial Discrimination, state parties are legally obliged to condemn and undertake all possible actions to eradicate racial discrimination by any persons, organization or group in all forms by all appropriate means, including legislations. India has ratified the international covenants mentioned right now, creating legally binding obligations to abide by them to the degree that they are consistent with the provisions of the municipal law. The provisions of these international covenants can be harmoniously interpreted with our constitutional provisions. Even organization like International Labour Organization is working in 5 selected states, partnering with both government and NGOs to address the discrimination experienced by Dalits. The ILO Discrimination Convention number 111, 1958 prohibits unequal treatment of workers on different kinds of discriminatory grounds, including caste. Among the core conventions, India has ratified Discrimination Employment Occupation Convention number 111. The discussions held in International Labour Conference in 2007 mandated the involvement of the ILO on manual scavenging under its supervisory system. Now coming to the constitutional perspective and bit of legislative history prior to the 1993 Act. In Maneka Gandhi's case and other cases as well as the Supreme Court of India has given a fresh aspect to Article 21 of the Constitution, wherein the right to live is not just limited to physical existence, but also the right to live with human dignity. You may also refer to Francis Corale versus Union Territory of Delhi, decided in 1978 by Supreme Court. Also People's Union for Democratic Rights versus Union of India, 1982 by Supreme Court. In Delhi, Jal Board versus National Campaign for Dignity and Rights of Sewage and Allied Workers and others, 2011, the Supreme Court has said that it is the obligation of the state and its instrumentalities to ensure appropriate mechanism for safety and protection of sewage workers. It is significant to consider the words of Professor M.P. Jain in the context of interpreting right to life. The right to live is fulfilled in its right spirit only when life is enjoyed and where an individual has access to the bare necessities in life such as adequate nutrition, clothing and shelter and facilities for reading, writing and expressing ourselves in diverse forms, freely moving about and mixing and commingling with fellow human beings. Human dignity is uninfringible and it must be always defended. The dignity of the human person also constitutes the basis of fundamental rights in our Constitution. The Supreme Court has emphasized in several cases about the state's duty to the life, liberty and dignity and worth of an individual, which should not be jeopardized, whereby the state is required to ensure that fundamental rights under the Constitution can be ensured to individuals engaged in manual scavenging too. A number of provisions in the Indian Constitution can be interpreted to prohibit the practice of manual scavenging. However, Articles 17 and 25 are directly relevant. Article 17 abolishes untouchability in all forms. Under the Untouchability Offences Act 1955, enforcement of any disability arising out of untouchability is treated as an offence. The Act is now called the Protection of Civil Rights Act 1955. The Scheduled Castes and Scheduled Tribes Prevention of Atrocities Amendment Act 2015 provides severe punishments and more protections for the protection of the scheduled castes and the scheduled tribes. Article 23 prohibits traffic in human beings and forced labor. Manual scavenging represents both the practice of untouchability and forced labor as well, when force is understood in the larger context, including force of traditions and discriminatory practices. Manual scavengers face discrimination under other provisions of the Constitution as well, like Article 14, which declares all persons equal before the law, and Article 15, which prohibits discrimination on grounds of religion, caste and sex. The Supreme Court had ordered the eradication of manual scavenging and asked state governments to provide financial assistance and rehabilitation to those who had lost a family member to the inhuman practice. It also ordered the government to pay ₹10 lakhs to the family of those who died cleaning sewers since 1993 in Safai Karamchari Andolan and others versus Union of India and others as decided in 2003. However, you may also refer to Safai Karamchari Andolan and others versus Union of India and others as decided on 27th of March 2014. The Untouchability Offences Act 1955, while making untouchability an unlawful and a punishable offence, did not acknowledge manual scavenging directly. However, under its provisions, imposing on anyone else a practice or profession on account of untouchability became a crime, and this in effect makes manual scavenging a crime too. However, the penalty of imprisonment for 6 months or fine of ₹500 was weak and hardly enforced. Compelling any person on grounds of untouchability to scavenge was made an offence punishable by imprisonment for the first time expressly under Section 7 capital A, which was introduced in the 1976 in the PCRA Act. However, it did not stop the practice of manual scavenging, as it continued to suffer from weak penalties, dismal implementation, besides low awareness of the content and use of legal provisions. The SC/ST Prevention of Atrocities Act 1989 was considered to be a much stronger law to prevent and punish acts, crimes of untouchability and violence, but it made little impact on the continuance of manual scavenging and failed in addressing the humiliation suffered by them. The Parliament enacted the employment of manual scavengers and construction of dry latrines, Prohibition Act 1993, making voluntary employment of manual scavengers for removing excreta an offence, but it was notified after 4 years. State governments took up to 18 years to even notify the act. However, the law was rarely enforced. The major reason for the poor response to this statute was that the governments have treated this as an issue of sanitation rather than human dignity as assured to all citizens by the Constitution. The law also suffered a flaw of restrictive definition of manual scavenging, as it did not cover people employed to clear, carry and dispose human excreta in places other than the dry latrines like sewers, septic tanks and drains, where human excreta are washed on railway tracks and in rail toilets. Abolishing manual scavenging became virtually impossible because of adding preconditions like the existence of adequate facilities for use of water sealed latrines. The said act put the protection and improvement of environment and public health as their priority compared to eradicating the discrimination meted out to the Dalits. The duty to rehabilitate under the act is not binding under the law, as it is dependent on wordings like as far as practicable and also try to. The act did not have any punitive provisions for the public officials who deliberately and willfully failed to implement the provisions of the law. The statute did not have any provisions for demolition of dry latrines as well. Now, coming to the legal development related to manual scavenging post 2013. After the extremely poor implementation of the 1993 Act, a new bill was drafted in regulating manual scavengers. It was further enacted under the concurrent list of the Constitution and was passed by both Houses of Parliament on September 7, 2013 as the Prohibition of Employment and Manual Scavengers and their Rehabilitation Act 2013, hereafter which will be referred as the Act. As per ILO, the 2013 Act is essentially a stronger law prohibiting and punishing manual scavenging. Now, we will quickly go through the salient features of the 2013 Act. The term manual scavenger is defined as a person who manually cleans or disposes of human excreta in an insanitary latrine, an open drain or railway track, as under section 2, subsection 1, clause G of the Act. Some of the basic prohibitions. The law prohibits the employment of a person as a manual scavenger under section 5 of the Act. The employment of an individual for the hazardous cleaning, that is manual cleaning without protective gear and other safety precautions, of a sewer or a septic tank under section 7 of the Act, and also the construction of insanitary latrines again under section 5 of the Act. Section 13 provides for the rehabilitation of people currently engaged in the profession. The law supersedes the 1993 Act and state laws on manual scavenging as per the section 3 of the Act. Certain provisions related to the identification of insanitary latrines and manual scavengers will be discussed. As per section 4 of the Act, local authorities like municipality, panchayat, cantonment board or railway authority, etc., have to conduct a survey of insanitary latrines within its jurisdiction. A list of such latrines has to be published within 2 months of the law coming into force, and the said authorities have to give notice to the occupiers to either demolish or convert them into sanitary latrines within 6 months. The chief executive officer of a municipality or a panchayat may carry out a survey to identify manual scavengers under the statute as per section 11 of the Act. Individuals can also self-identify as Manual Scavengers Act under section 12 of the Act. Certain provisions related to the prohibition and conversion of insanitary latrines will be discussed. Every occupier or owner of an insanitary latrine should demolish, convert the latrine into a sanitary latrine at his own expense within 6 months of the Act coming into effect. If the person fails to do so, the local authority has the power to convert or demolish the latrine and also be entitled to recover the cost from the occupier as per section 4 of the Act. Assistance may be provided to occupiers by the state governments for converting latrines. However, lack of assistance shall not be a lawful ground to use an insanitary latrine beyond 9 months of the law in force as per section 4. Each local authority should carry out awareness campaigns to implement the above provisions of the law. Certain provisions related to prohibition and rehabilitation of manual scavengers will be discussed now. Now, existing contracts with manual scavengers shall be void from the commencement of the Act as per section 6 of the Act. However, the employer shall re-engage full-time scavengers on the same salary and assign different work to them. All manual scavengers shall be rehabilitated with one-time cash assistance, scholarship shall also be provided for their children, and a residential plot shall also be provided in addition to any other financial assistance for constructing a house. One adult member of the family shall be trained in a vocational skill and be given a monthly stipend of at least Rs 3,000 during the training. A subsidy and concessional loan should also be given for taking up an alternative occupation under the statute as directed by section 13 of the Act. Now, we will discuss the penalties under the Act. Section 8 of the statute imposes a penalty for employing manual scavengers or failing to demolish insanitary latrines with imprisonment of 1 year and or a fine of Rs 50,000 for the first offence. Subsequent offences will attract imprisonment up to 2 years and or a fine of Rs 1 lakh. Section 9 makes hazardous cleaning of septic tanks and sewers an offence punishable with imprisonment of 2 years and or a fine of Rs 2 lakhs for the first offence and 5 years and or a fine of Rs 5 lakhs for subsequent offences. As per section 22 of the Act, the offences have been made cognizable and non-billable. As per section 21, the state government can confer powers of a judicial magistrate of the first class on an executive magistrate to conduct trials under the statute. The statute requires the complaints to be filed before the court within 3 months of the offence committed. Now, speaking about the implementing authorities under the Act, section 13 empowers each district magistrate and local authority is responsible for ensuring that no person within his jurisdiction is engaged as a manual scavenger. Further, no sanitary latrines are constructed or maintained or used. Also, manual scavengers are rehabilitated and offenders of the Act are investigated and prosecuted. The state government can appoint subordinate officers and inspectors in addition to the district magistrate who shall be responsible for carrying out the following duties under section 20 of the Act, like examining of latrines, open drains, premises to establish offence under this Act, examining a person employed as manual scavenger, also seizing relevant records establishing offence on the part of the employer. Under section 33, the law mandates that the implementing authorities create provisions for the construction of an adequate number of sanitary community latrines to eradicate open defecation within their jurisdiction and for the use of appropriate technological appliances for cleaning sewers and septic tanks. Central and state monitoring committees and vigilance committees shall be established in each district to oversee implementation. The National Commission for Safai Karmcharis, which is a statutory body formed under the National Commission for Safai Karmcharis Act 1993, is entrusted with the task of monitoring the implementation and inquiring into the complaints about contraventions of the Act. Now, coming to some criticisms. Despite efforts to prohibit manual scavenging and bringing back dignity in their life, the legislation suffers from some shortcomings. The Act enacted under entry 24, that is welfare of labour and working conditions of the concurrent list, in spite of having number 1, wider definition of the manual scavengers, number 2, prohibiting hazardous cleaning of sewer and septic tanks, and number 3, imposing stringent penalties and rehabilitation, is weak when compared to the 2011 draft, which was titled as Total Liberation, Comprehensive Rehabilitation and Humanization of Working Conditions Act 2011. Unlike the 2011 draft, which proposed to provide pension to the elderly manual scavengers and proposed to direct the Ministry of Railways to reserve a quota to absorb ex-scavengers as railway catering staff, the Act provides rehabilitation to be directed and subjects it to eligibility based on identification surveys carried out in rural and urban areas. The Act also provides for displaying to public the final list of urban manual scavengers identified in the survey and to invite objections from public, which would add to the humiliation to the manual scavengers. Also excluding a person who handles excreta with the help of protective gear from the definition of manual scavenger contradicts the stated intention of rehabilitating these workers out of such dehumanizing work. To conclude, I would say abolition of untouchability is a constitutional mandate, and to that end we have several laws including the Prohibition of Employment as Manual Scavengers and the Rehabilitation Act 2013. The governments in centre and states are both to play a proactive role to fulfill the statutory as well as the constitutional goals. Therefore, the responsibility of eliminating manual scavenging rests on the central and state governments equally. It is only with their concerted efforts can we eradicate this dehumanizing practice in India. Various schemes and policies of the government have borne some results, but have fallen short in liberating all the manual scavengers. Overall success of this statute needs all the dominant castes and the society at large to change and work towards meeting the constitutional values to ensure that each of the manual scavengers and their dependents can live their life with dignity. To summarize, I will quickly mention few points. Number 1, employment of manual scavengers is prohibited under the Act, along with manual cleaning of septic tanks without protective equipment and the construction of insanitary latrines. Secondly, a wider definition has been provided under the Act to the term manual scavenger, and the same includes persons engaged or employed for manual cleaning of human excreta in an insanitary latrine or in an open drain or pit, railway tracks, etc. Thirdly, definite provisions have been provided for the identification of manual scavengers and insanitary latrines. Fourthly, hazardous manual cleaning of septic tanks and sewers has been prohibited to ensure that health and safety of such workers. Fifthly, stringent penal provisions have also been provided for violations of the new Act. Sixthly, the Act provides for setting up of vigilance and monitoring committees at the subdivision, district, state and central levels. Seventhly, offences under the Act have been made cognizable and non-bailable, and courts have been empowered to try the same summarily. Lastly, it is the duty of every local authority to use appropriate technological tools for cleaning. Thank you.